Hello, today we'll talk about section 15 of the CPC. The section 15 of the CPC states that every suit must be instituted in the court of the lowest grade which is competent to try it. So this section is basically referring to pecuniary jurisdiction. Uh, for example, there is a small causes court and it has a limit of 10,000. Then all the cases of say 8,000 or up to 10,000, anything up to that amount should be instituted, of course, in that court. And what will be the effect? Suppose that is the normal, if there is say 10,000 limit is given, then one has to go in that court. But suppose what will happen if the person, instead of going to the, suppose his lowest court, he went to a court with the higher pecuniary jurisdiction, what will happen? So the effect will be, obviously the court which has a higher pecuniary jurisdiction, they will obviously not lose it, they still have the jurisdiction, and this is a procedural law. So section 15 is purely procedural. So suppose if a person went, suppose instead of city civil court with his plaint of 10,000, instead of going there he went suppose to city civil court, and he filed the plaint there, and subsequently the plaint was accepted and decree and etc., order etc. was passed. So that is obviously valid, because the section, as per the section 15, you are required, any person is required to go to the court of the lowest grade which is competent to try it. But suppose instead of going there, a person went to higher court by mistake or whatever reason, and if the court accepted it, then obviously he has a jurisdiction. We can understand this by a very simple example. We don't even have to even forget about law, but even in the normal day to day working, all the organizations work in this principle only. Not just the organization, but many other things also. Suppose uh, you go in any company, you are working, and there is a, suppose a junior accountant who can deal with the any query of yours up to 10,000 or 50,000, whatever is the amount. Then obviously for that amount you need to go to their junior accountant only. Why you have to go to the chief accountant? Because obviously the machinery is provided, the grade wise system is made in every organization. So similarly in courts also there is a need, obviously. Because, and the other thing is, suppose when whatever your problem is, whatever the problem is, that can be solved by, suppose you are working in some company, you went to the another company, and as per that company, whatever your query is, whatever your complaint, it can be dealt with it by the junior accountant up to, suppose 10,000, 50,000. Then obviously you have to go there. Why you have to go all the way to the chief accountant? It makes no logic. That's how not just the court work, but everybody, every organization, every institution work. Secondly, suppose instead of going to the junior accountant, you directly went to the, say, senior accountant, or directly to the chief accountant. Then does that mean that he does not have the authority to deal with the matters which are subordinate to him? Obviously he does not loses that jurisdiction. He still has the authority, because the junior and all these accountant are under whom? Under the chief accountant. So this is just an example to explain what the logic behind that, and it's not a big logic also, it's very simple, but still sometimes we have to understand from different perspective also in order to remember something. So anyway, so this is the logic behind the section 15. And the other question is, suppose on what basis the pecuniary jurisdiction will be decided? Will it be decided on the basis of the decreed amount, the ultimate whatever the decision came of that decreed amount? No, the amount which is mentioned in the plaint, that will be considered. So the court will only look at the amount which is mentioned in the plaint. And suppose if you went for a suit of say 10,000 is due, and the court said no, not 10,000, but actually you got 50,000, 15,000 or whatever amount, then in that case actually the court limit was 10,000 when you went, but when the judgment came, the court said no, you will not get 10,000, you are supposed to get 15,000. So in that case, that jurisdiction will not be ousted. So the jurisdiction that we are talking about under the section 15 of the CPC, that will apply. Where it will apply? It will apply in the plaint. In the plaint, if you have mentioned 10,000, then that will be the basis for considering the jurisdiction. And the final thing about this section is, generally court will not bother much about the amount that you have mentioned. Generally court will assume that whatever you have mentioned, the amount, the claim, the relief that you want, the amount is actually at least true. But if the court has the doubt, a suspicion that the amount that you have mentioned in the plaint is not true, then the court will ask you to provide for the calculation of the amount. How did you arrive to this amount? And suppose if you are able to prove it to the court that this was a calculation for making your claim up to particular, then the court will accept it. And if the court has no counter or calculator, nothing to prove you wrong, then court will accept, suppose, whatever you have given. So this is the section 15. Then there is section 16 to 18 about immovable property cases where it has to be sued, and that we will talk in the another video. This section is specifically for section 15, and please share and subscribe to my channel if you like it, and thank you very much.